Dear participants, dear friends, this global digital encounter is dedicated to Eastern Asia, the new paradise for patenting. In the wake of the creation of the World Trade Organization 30 years ago now, and the subsequent immense development of world trade, countries of Eastern, Southern, and Southeast Asia steadily develop their economies, steadily develop their research capacities, with a long period of growth and of wealth development. This period was not linear, was not equal between all countries, but from little patent players, several of them managed to develop fast research, fast results, high quality results, thanks to foreign and domestic investments. And these results that were resilient resulted in patents. This impressive growth of patent statistics that come from this part of the world is watched from all the planet, is watched with much interest and admiration. Countries as different as the Republic of Korea, as China, but also other countries in the region really embarked with success in this direction. In this race, analysts perceive the region of Eastern Asia as a new paradise for patents. Is this analysis really correct? Which consequences for all of us? Is this growth to continue? What does it mean for the losers? Or will there be limits to new winners? What differences between maintenance rate? And so on. For this very session, we have marvelous and extremely respected speakers from Eastern and Southeast Asia. We have with us, of course, Professor Hong Xue from China. We have Professor Levan An from Vietnam, and we have Professor Liu Kung Chung from Singapore Management University. As such, we are extremely honored that these esteemed colleagues can be with us today. You have their full biodata on our website. In the Global Digital Encounters, there will be, as usual, a report after this session. This session will be recorded, so you will access the recording for you and for also all your friends. And there is already a list of readings that go further than what we can develop in the 60 minutes that we have at our disposal. Before closing this quick introduction, I would wish to warmly thank all our supporters, all our pro bono supporters. This activity is organized by the Fide Foundation, together with the Transatlantic IP Academy. We are very, very honored of this activity together with our pro bono sponsors. And we thank all our participants from all over the planet who are connected today. It is morning in Europe, it is night in America, it is afternoon in Asia. And we are super happy to have all of you from all over the planet. With these words, I leave the floor to my colleague and friend, Javier Fernandez-Lasqueti, coordinator of the Global Digital Encounter project, next to Professor Manuel de Santes and myself as co-directors of this project. Javier, the floor is yours.
Thank you, Laurent. Yes, you're right. We are very, very happy of this encounter of today and the topic and the participants, the speakers and you as a moderator. Well, it's clear that Asia is playing a relevant role in the patent field. You only have to take a look to the statistics coming from EPO, the PCT, etc. And you will see that Asian companies are major players. It's not from yesterday, it's from a long time ago. So it seems that the economy of that countries is very interested on the innovation, is very interested on protecting the innovation. So we are as Europeans and as Americans, for those that are Americans, but myself as a European, we should keep an eye on Asia, and we have to see and hear what's going on in that countries, because they have a vibrant and important economy. So I'm very happy for having you here. Thank you for coming, and thank you for participating in this encounter. And thank you to you all members of this community for being with us as usual. And remember, we are a community. And that's all from my side, because I want to hear the speakers. So thank you very much, Laura. The floor is yours again.
You are welcome. Thank you to all participants again, and of course to our friend Javier. At this very stage, as per our global digital encounters tradition, in my capacity of moderator, I would wish to raise a few questions to my distinguished colleagues, Xue, Kung Chung, and of course, Van Am. So we see this immense growth. We admire from Europe and America this immense growth of Eastern and Southeastern Asian countries. But how and why patent statistics grow so fast in Eastern and Southeast Asia? And how we know why, and what are the differences? I would wish to raise this question to all of you. Perhaps I understand that Kung Chung may wish to reply first to this, and then we will go around the table and discuss this matter. Kung Chung, the floor is yours.
Yes, okay. Thank you for the kind invitation, and also thank you for your interest in the IP law in Asia. Indeed, in the last several decades, especially East Asia is experiencing the boom in the patenting and the actual registrations of patents. So if you look at the statistic, the big 3 out of the big 5 patent office are in Asia. So JPO and KPO and CPO. So as a matter of fact, through in the process of industrializations, some of us managed to migrate from the imitator to innovator. And so that is driven, I think, mostly by the industrializations. And again, luckily, this industrialization process is taking place right now in Southeast Asia. Ironically, thanks to the U.S. decoupling with China. So not only Chinese companies are diversifying their investment in Southeast Asia, but also other major investors are also diversifying in Southeast Asia. So with industrializations, it's only natural that you try to protect the result of your new inventions. So that is one thing. But also we know people in Asia, we are very modest though. So I like to remind you that although we have astronomical increase in numbers, especially in China, but overall we are still net IP importer rather than exporter. So the only exception in the whole of Asia is Japan. Japan managed to export more IP and import than it imports. So we have to be realistic about the technological strengths of this economy. And I also know that although we talked about East Asian today, but we should never overlook the potentials of India. So the industrialization is happening rapidly in India, and the Indian people are just as smart as other Asian and hardworking as other Asian people. We don't take holidays also. We want to catch up very badly. So we should not overlook India either. So with the increase of number, I think, but basically, people get more confidence, and also people see the success story being repeated in East Asia, so that you pay for a patent as liability, but then with the accumulations of capital and technology, then you build up your own patent portfolio, and then with that, at least you can defend your company from the patent litigations, and that pattern has then been repeated countries after countries, and with the diversifications that we now focused on focusing more on Southeast Asia, I think Southeast Asian country will repeat that patent success story. So I don't want to take up too much time. With that, I'll go close first. Thank you.
Yes, thank you very much. I would wish to give the floor now to Xue. If you have comments on this. I would wish to remind that we will also dedicate later on an additional Global Digital Encounter to India. But now we are with China, thanks to Xue.
Well, thank you, Lorraine. Very nice to be here. Nice to meet all the friends, old and new. I'm honored to join you. Okay, all of these questions extremely interesting. I'm especially interested in the introduction when you mentioned the patent paradise. I'd really like to know what is the meaning, what is your definition to paradise? As far as I know, when we talk about tax heaven or copyright heaven, it does not mean very good things. Hopefully the patent paradise means something that's really good. Firstly, yes, as I said by the previous experts, we see the phenomenon development as a large number of patents has been granted in these jurisdictions in East Asia. That's crystal clear. But issue here is that it is the more the better. We got more patents that's become a paradise. That's really a question. If you allow me, I'd like to move on to your second part. That's why. Yes, we want to know why. Why we got so many applications and also so many patents granted. I guess that's really something we should have a deep dive. We want to look into the reasons. What's behind this? Well, for me, although I'm very interested in Southeast Asia, the ASEAN country, 10 jurisdictions, extremely interesting. There's no uniform jurisdiction, but I'm so interested, especially the diversified approaches to the patent criteria. Allow me to focus on the experience from China. What's behind this? This may be quite unique. This is Professor Liu said that something is reproducible. Hopefully, this is something Southeast Asian countries could look at. For China, it has been a WTO economy since 2001, and China issued the national IPR strategy from 2008. I guess that is the beginning of this patent booming, because the strategy used some very stimulate policies and evaluation criteria to push for more patent application. There have been a kind of official survey completed by the Patent Office of China since 2016. According to their survey, the most latest research has been completed in 2022. Well, I don't know why 2023's report is not being released, but we can see that the trend is very clear from 2017 to 2022. The number of patents that's been granted for Chinese patentees doubled from 200,000 to almost 800,000. This is include not only domestic patent granted, but also through PCT. We call them overseas patents. So you can see that, well, this is really remarkable, the growth. And the application number is even more, phenomenal. So what I can see that there's more patent is clear Under our law, we try to separate 3 categories of patents as invention, utility, modern designs. I will I will label it if it's necessary. What I'm referring to is invention or all 3 categories of patents. For the patentees, well, the research tried to separate enterprise patents, universities patents, and research institutes patents. So there's 3 types of patentees. Well, for the motivation, as we gathered from the research, it is very, very interesting discovery. Almost 90% of enterprises well, respond to the survey that they want to enrich, first of all, their technological portfolio. Yes, they want to put it in their technical portfolio. That's one of their possible assets. And secondly, most importantly, they want to get the patent in order to support their obligation for governmental projects. For example, they could be eligible to be a high-tech enterprises. And in that case, they got the special status to get a governmental investment or get the loans from the bank, or even has a favorable treatment for taxes, maybe some tax exemption. And we can see if 90% for this reason, only 10% or less than 10 left for real tech transfer reasons to get the benefit. So the licensing and assignment rate is really low. Well, this is really unfortunate situation. Let's look at universities, what I know very well. I'm actually one of the officers in my university's patent office. We have to say 90% or more than 90% of the university apply for patents because they want to protect their technical innovations. That's very clear. And second most important reason for this is to get the academic promotions. Well, this is primarily for those inventors. We were all professors. We're working in the professorial career. So for young people to get a promotion, they need to show some outputs, academic outputs, and these patents can be a good proof. So you can see, in conclusion, that is decisive factors influencing this paradise. It's some patent stimulation policy or strategies, and also the rewarding or evaluation systems. I would summarize that's the reason behind this. Okay, back to you, Lauren. Thank you.
Thank you very much. Thank you very much. Indeed, while thinking about this positive paradise of patenting, as mentioned, we Europeans, especially for the audience that is connected from Europe, we should remember that some countries rightly grant promotions to their university professors and researchers thanks to patents, something that in Europe is not that generalized, and in America is not that generalized. So the virtuous paradise example of Asia, combined with high quality patent search and examination, is something that is admired from our side of the Eurasian continent. Van An, I think you want to add something from, in particular, connected to the Vietnam example, which is a fast-growing economy of Asia. So 100 million inhabitants, a fast-developing economy, also moving towards this direction. Anan?
Yes, hi, thank you. Thanks for inviting me here. So in order to build up the answer, I want to refer to Professor Liu about like a lot of Asian countries are to net IP importer, and I totally agree with that. For example, if we look at the patent statistic in Vietnam, I think the paradise is for the foreign patentees rather than for the domestic inventors. So 90% of the patents in Vietnam are filed by the foreigners and only 10% by Vietnamese. And for the patent granted, the rate is 50% for the foreign patentees are granted, only 17% for domestic inventors. So we can see a very big gap between domestic and foreign patentees. And in case of Vietnam, what explains for the a fast developing of the patent statistics can be mainly attributed to two factors. The first is the country has a very low starting point compared to countries like China or Singapore. So when I say low starting point, we shouldn't forget that Vietnam built a patent system based on the Soviet model. So with the inventor certificate, and the country only opened up its economy in 1995 and then became a WTO member in 2007. So if we look at the chart, we can see that the patent filing activities started to kick off somewhere in 2000 and accelerated after Vietnam became the member of the WTO. But as I mentioned, in general, it's still the playing field for the foreign patentees rather than for domestic inventors. And a second reason I also want to mention is Vietnam had its first patent law in 2005, so under like 20 years. And it just 2 years before it joined the WTO, it quickly adopted the Patent Act. So with this like relatively short period, the country created an impression that there is a rapid growth in patent statistics. When I heard Professor Hong Sui talking about how academia in China pay attention to patenting, it hit me a lot because it seemed that in Vietnam, especially in the STEM industry in university, that area is not really paid attention to. I think mostly because like Vietnam is still in its very early stage of the patent development. So universities have not paid attention enough to that area, and even when they do, they don't know how. They don't know where to start. And it's very interesting to hear Professor Hong mention like patenting inventors play a role in academic promotion. I am not fully aware that happened in Vietnam, or to the best of my knowledge, I haven't heard patenting will play an important role. So I think if we look at the picture holistically, the government in Vietnam, I think, still need to a lot more to do, not only like not from the policy, industrial policy, but also like in other areas, social, also a good way to put the patent statistic.
Thank you very much, Van An, for these words. Indeed, you explained, while explaining the how, you also explained the differences between these countries. The three of you were very clear on this. We also see that China has an immense advance because of its size, of its markets, of the laws that were adopted very quickly, and also receives a lot of foreign patent applications, but because of its size and immense research efforts, has a lot of national patenting. Whereas, of course, countries that are more recent or of smaller size, like Singapore, necessarily receive a lot of foreign patent applications. So on this, there is, as it happens in Europe for smaller countries, there is not much difference, and this is really an interesting picture of unity and diversity in the Eastern and Southeastern Asian region. Do you think, my dear and esteemed colleagues, do you think that this process of growth, of splendid growth, will continue? This is perhaps a bet, but let's try to reply quickly to this question. I would, of course, raise the question first to Xue, to Professor Hong Sui, as you come from the largest, without any doubt, the far largest patent applicant country.
Oh, thank you, Lorraine. Yes, that's exactly I want to respond. I really want to let you know what is the consequence of this policy as William mentioned that's my observation about this evaluation system. Yes, it is the facts, but I don't mean I agree with that, and I didn't see the problem with that. So let's look at the consequence of this policy and whether it is sustainable. Well, this patent booming was a leapfrog. A great leap forward has some consequence, and some of them are actually negative. That's why we're actually reforming the patent system. The first thing is that the better policy has actually resulted in more low quality and less innovative patents. So we are now actually improving the patent quality. And it's now implemented new measure to improve the invention patent examinations efficiency and the quality. So that's one consequence. I'm saying that too many patents may not be very good. The second consequence, well, that is even more relevant to our discussion. I see, Lauren has already noticed that there's a lower maintenance rates in China than in country in Europe. That's true. And also the lower implementation rate, not only maintenance rates. As I mentioned, if most of the patentees acquire the patent not for the purpose of implementation of the patent, rather for something else, from some external or the other considerations, such as to be eligible to be a high-tech technology or to get the professorial promotion, and then that these patents has completed its mission, the moment it's been granted, because it's only valuable on paper, right? Once it's been granted, it is already valuable to the patentee. They don't have to bother to put it in application, in industrial production. That's a big, big problem. Because it haven't been implemented, of course, they won't pay the cost annual fee to maintain its validity. That's why maintenance rate is lower. According to the figure from 2022, 2 years ago, implementation rates overall for all the patents granted in China is roughly 58%. So you see less than 60%. When we look at invention only, the implementation rates is only 36%. This is very unfortunate. So it's only 1/3 patent has been implemented. This is very unfortunate. When we look at licensing and assignments, the rate is even lower. Licensing rate is about 9%. Assignment rate is 5%. So you see that so many patents are sleeping patents. They're not sleeping beauties. These are sleeping problems. When these resources has been invested in this creation and eventually patent granted, they were not really implemented. That's a very big problem. Okay, I'll stop here. I'm happy to answer any question. Lorraine.
Thank you very much. Thank you very much. Kung Chung, Leanne,
Yes.
you have additional
Yes.
question?
Yes, I think generally with the industrial growth will come the increase in patenting. It is the general trend. But specifically, I want to point out that Japan, they now is going through re-industrialization. They are recovering from the economic loss of the last 30 years. So I clearly see that there's this momentum into re-industrialization and effort, and also that will increase the patenting. But otherwise, the Japanese has been quite stable in the last 10 years. They have some around 300,000 patenting and registered patent. And also, but Taiwan is a very interesting other example in the sense that the patenting has been reducing rather than increasing. Not that its industrialization has stopped, but rather they have very strong trade secret protections law that is coupled with very severe criminal punishment. Then for inventors, they see that there's no point in patenting because patenting is very costly. Patenting don't get the help from the state prosecutors, so they relied on the trade secret protections because then it can rely on the police and the state prosecutions, and especially during this geopolitical era where the national interests play more important role, and people are subject to all kinds of economic espionage charges. And in Asia, once you are subject to criminal charges, it has very strong smearing effect over your enterprises. So I think Taiwan is perhaps perhaps the only exceptions to the growth in patenting, because the patenting has been taken off, trade-off with trade secret protections. And in Singapore, let me add quickly to Singapore. Singapore is different from Hong Kong, so you might be mistaken in thinking, well, Singapore is a financial hub. Yeah, it is, but actually the number one industry sector in Singapore is manufacturing, not financial, not shipping. So we have set up very robust patent office. We have 106 patent examiners which have a bilingual skills. So we are receiving more and more patent applications from local industry as well. Thank you.
Yes, focusing on obviously on Japan and Singapore. The Japanese example is very symptomatic, but it is said that Japan goes to reindustrialization, still its patent statistics remain flat, whereas we learn from the past, but this may change, that normally there is patenting precedes reindustrialization. So will this take place in Japan? Will other solutions, such as larger use of trade secrets, in particular with AI, be a Japanese way, since Japan invests a lot on robotics? We shall see. Levan, please.
Sorry, yes, I think, yes, yeah, I agree with both Professor Hong Sui and Kung Chung Liu that this trend will continue also in Vietnam, partially because now not only Vietnam, but also Southeast Asian countries are the global hub of manufacturing because of, the geopolitical issues, and also many countries are the members of biggest trade deals in the world, like the CPTPP or CEP. So many investors have started investing and expanded their investment in those countries, and therefore the demand to protecting their IP has been increased more. However, I also agree that the story of quality is something else. So I think for Vietnam, this trend will continue, as I mentioned, because it has a very low starting point, and the countries now want to attract more the investment. So the industrial policy will be more open and in favor to attract the foreign investor. However, as I mentioned, we need to take into account the patent quality, and so far there has not been too much research about the patent quality in Vietnam, so I cannot speak so anything about it.
Thank you so much to our esteemed speakers. Time flies, and now we need to switch to the fantastic questions that I can see in the chat. And in particular, I have one question from Alexander Berinsky, who asks to Professor Hong, how many patentees from universities and research universities, if any, participate in the booming patent litigation in China, enforcing their patents? I think this is a fantastic question.
Oh, this is fantastic questions. Oh, yes. Well, as far as I know, well, I may need to check the research and the numbers. But to my memory, the three categories of patentees each take 1/3 of the patent. So roughly the universities, well, along with research institutes and enterprise, save actually about 30%, more than 30% of all the patentees. Yes, so the university actually produce a lot of patents, right? Okay.
I think. Sorry.
Sorry. Go ahead.
Yeah, I think this is a very interesting question. If we compare to Europe and America, thanks to your words, actually, we see that universities, clearly enough, have a lot of difficulties in being enforcers. This is self-evident in Europe and North America, simply because our budget, the construction of the patent system makes that universities are big or small players in the patent race, but enforcing is something very difficult for university, in particular because the fixed budgets of the universities are different than the ones of companies. So enforcement is really, really a challenge. I don't know if Van An or Kung Chung want to add on this. Van An, no. Kung Chung, no. So I have another fantastic questions, well, 3 questions, this time for Kung Chung, for Professor Liu. In the past, you have said, Professor Liu, in your esteemed writings, that SEP licensing has become a thorny issue for major Asian economies because those economies are standard takers and they have strong manufacturing sectors. That is dependent clearly on standard and standard essential patents. How do you think the recent developments in the European Union affect Asian economies? Indeed, the European Parliament, as we know, last 27th of February, adopted the standard essential patent text that is likely to be adopted by the Council. Do you think that the adoption of this proposed regulation would be beneficial to Asian countries such as China? There are also additional questions, but I would let you first reply to this fascinating question from Axel Ferrazzini.
Thank you for this great questions. Actually, we have some short discussions before we start the program. So I was following this SEP regulation legislations in Europe very closely. And I was told that actually it was driven by the German industry, like many law has been driven by German industry. And the people who told me this assure me that this legislations will pass for sure. And I've read this draft regulation, and I like its idea very much, because it pretty much takes up every suggestion that I have made in 2019 in the book that I co-edited with Professor Reto Hilty. So I think it's important that we set up some mechanism to verify the essentiality of this declared SEP. Otherwise, then there will be an overflow of SEP, and also we need to be able to in the know. At least some people, some expert must be in the know about how and why frame compliant terms are being decided. Not the current situation is not sustainable anymore, because no one know how frame compliant terms are being decided, because it is all on the trade secret protections. In my whole life, although I studied this for a long time, I never managed to be able to really even look at one important patent licensing agreement. And even if I managed to do that, I will be subject to a confidentiality obligation not to disclose it, not to discuss it. If it keeps going like this, there's no way that we can solve this issue. And by having putting in place some kind of mechanism that can be the depository of frame compliant terms and conditions, or by putting in place some mechanism that will verify the essentiality, I think that will help to solve these issues. But whether Alicante is the best place for people to do that, I think that many people will have their doubt, because Alicante is a nice place sunbathing, for pleasure, but it's not a serious place for doing technical thing. Pardon my disrespectful comment on Alicante, a city I visited some 30 years ago. I think people will have its doubt when it comes to its technical capability to do the actual essentiality check. But other than that, I think the idea is good and the direction is also agreeable. And then if you take the lead, I mean, the European take the lead, I think very likely, but Professor Xue can correct me, but I think very likely China will take it very seriously, because China is also very interesting in regulating SEP, and they are becoming also owner of SEP, so they want to have bright line rules rather than just leave everything to courts. Okay, perhaps I will stop here.
Thank you very much, Professor Liu. Thank you very much, Kung Chung. Well, indeed, this regulation on which I worked a lot was prompted by on which I had some doubts, as you expressed, was prompted by the German automotive industry and only this sector, and applauded by Apple, but supported very much by Apple as it is known. Yes, we'll perhaps Professor Hong Xue, do you want to add something on this? China may be the big winner of this, may follow this path. What are your views?
Well, thank you. Well, I don't know whether China will be a big winner of this, but yes, this is a big issue and being closely watched by China, pretty sure. Well, for this proposal, actually, I can see some positive elements. Probably you heard about very unfortunate series of suits, counter suits. Well, a series of counter injunctions issued from the courts in Europe and courts from China. They all impose injunction against the other party from suing or imposing the licensing fees. Oh, that's so unfortunate. So there must be a solution to this. So I guess in this proposal, it proposed this competence center to could have a mechanism to determine the friend licensing rates. I guess it's not a bad idea, but whether it's kind of mediation with arbitration, or this is a kind of a unification of jurisdiction. I don't know. I see you smiling. Probably you have better idea to this. But indeed, it's being discussed in China, and I guess once it's become a law, well, there's so many. We can feel the Brussels effects. Definitely, yes. The AI acts just become alive, and there's now more coming. And yeah, probably you could brief us what will be really implemented, this competence center approach. Yeah, back to you.
Yes, thank you very much, Xue. Yes, actually, I smile because I totally support your views and share your views on the question marks. So we are not too sure of what it will become. There is no single doubt, as Kung Chung has indicated, that it will take some time to establish a competence center at EU IPO. We can bet that these proposals were adopted very, very quickly, because there are the European Parliament elections in June, and the idea of the European Commission was to finish and complete many aspects of its agenda, including the AI Act, before the June elections, which means an acceleration of the process in this respect. So then out of it, it will take some time to see and judge, and in particular to see if these proposals for standard essential patents that are practically adopted now that the Parliament has adopted it and the Council sounds to oppose, not to oppose. We shall see what it becomes. You mentioned also the seminal decision of the courts, in particular. Axel Ferrazzini raised the question on the Chongqing court that adopted a decision in this respect, and we therefore see that China embarks very much in in this direction. It is right that, as Alexander Berlinski points out, there has been many reservations from European sources, from USPTO, from other users on the approach that was taken. Yet it seems that the European legislator, through the Council of Ministers and through the Parliament, goes in this direction, goes too quickly, probably, without weighing fully the options on a topic that is super useful, as Kung Chung has mentioned, but at the same time, the EU moved very quickly, including giving competences on something so complex. So we will see what history tells us after the elections. Well, I don't know, Van Aan, you want to add something on this, or do you prefer to leave it? Okay. So at this very stage, I would wish to mention again the issue of the maintenance rates. Some of you, in particular, Xue, esteemed Professor Hong Xue, has raised the issue of the shorter maintenance rate in some Asian countries. From EPO statistics, if I remember well, we have a 6 years maintenance rate for China, whereas the EPO OECD one is around 8 years. So do we want to dig out further on this? Professor Van Aan, I see that you made signs in this respect. The floor is yours.
Yeah, so on the topic of the maintenance fees, I can say that Vietnam has a very low maintenance fees compared to other countries. That maintenance fees might be low if you compare with the foreign investors, and the purpose of the country setting such a low fee because they want to encourage domestic inventing activities. But as I mentioned at the beginning, it's still the playing field of foreign investor. So I don't think having the low maintenance fees would act as an incentive to encourage people to apply for more patents, because there will be a lot of other issues, not only the money issues. And I heard that the patent office is thinking of raising the patent fees in the future. But this is just, that's on from my side. I just want to contribute a little bit insight of why the country has such a low fee.
Yes, indeed, NOIP is thinking of raising the fees, but it is also noted that in general, fees are relatively low in Vietnam compared to other Asian, Eastern Asian, Southeast Asian countries. And this is a very interesting point of reflection, trying to push the national applicants through the fees, basically through easy fees, not through easy patenting. This is a positive paradise, as we have mentioned, but through easy fees, so that people are pushed to join the patent system. I see.
Can I just add one thing very quickly? So I think it's also part of the legacies of the Soviet legacy, because in the past with the inventor certificate, they were exempted from paying the fees. So only people who applied for the patents, they would pay the fee, but the people who opted for the inventor certificate didn't have to pay the fee. So I think it's kind of like carry on of the lingering legacy.
Yeah, but some non-Soviet countries or countries with no Soviet legacy, for example, Spain, have fees exemptions for universities as well. So in this very case, you are right that the Vietnamese comment, the Vietnamese approach, which is generalized with low fees, it comes from an inheritance. This is something, no doubt, fascinating. Kung Chung, I saw you made a sign. You want to add something on this?
No, not really, because perhaps Xue will.
Xue, you want to add, or you already mentioned? Yes.
Oh, okay. Well, this is so interesting. For well, let's go back to our beginning. This is the patent paradise. In the paradise, it should be free of charge. But actually, at least under our law, you have to pay the annual fees, the maintenance fees to keep your patent alive. And well, I guess it's consistent in Europe. The fee is incremental every year, so that the longer you maintain your patents, the more you have to pay to keep it valid. So there's a function for this maintenance fee, that is to stimulate you to implement your patent, right? So this not only stay on book, it should be in practices. So that, as I said, well, thanks to the question about university patents, I see, yes, many Chinese universities have got so many patents. Oh, well, they do pay the fees. They have the funding from the states. But issue here is that the rate of implementation is very low, so that the government has actually invented a new mechanism from 2020. It's called open licensing. I guess it's something we learned from UK. The open licensing means once you publicly listed your patents on a certain system, and eventually manage to conclude a license with the other party, your maintenance fee could be either reduced or exempted. Right, this is a new experiment. I know the devil is in detail. There's a lot of problem. I don't have to go into details, but I want to say that, yes, we are experiencing many things to try to make the patent both valid and implemented. Okay, back to you, Lauren.
Yes, I think this is really a very important thing. And also, the three of you, our three esteemed speakers, show that whereas there is an Asian, Eastern, Southeast Asian trend, there is no such model, because each country, like in Europe, has different rules on licensing, on maintenance rates, on exemptions, on taxes. So a paradise, but not the same paradise at each place. So this is why we are so happy to compare together. I have a last question before we conclude that has been a bit touched upon by Kung Chung, that I would wish to ask Xue and Van An on the role that trade secrets play in the sub-region. In particular, with the rise of artificial intelligence, the complications connected with patents and artificial intelligence, and though China is a big user of the patent system for artificial intelligence, how do you see the role of trade secrets in the sub-region? Will it grow? And my question will be initially, of course, to Xue on this.
Oh, okay. Well, AI is a big issue. It's as big as in Europe. But China has made a couple of regulations on AI. For patents, well, I can see the great potential from multiple perspectives. First of all, as far as I see, this is Professor Liu mentioned, we have a big patent office, more than 1,000 examiners. As far as I know, that they are actually introducing AI system. So I guess it will further improve the quality and the efficiency of the patent examination. Oh, that's one thing. For the AI related patent, yes, I do see the legal issues here. I guess as we can complete the doctoral thesis on this. For some of my PhD students are doing this. For my rough understanding, this is only my personal opinion. Well, invention completed with the help of AI won't be excluded from patent protection. But yes, the devil is in details. But well, here we should make it clear that the AI should be used as tools, not masters. If we did something really entirely, completely, essentially produced by the AI, not human being, then there's big question whether the algorithm designer, rather than these applicants, should get the patent. Yes, I guess we don't have time to go into the legal details. Back to you, Laurie.
Yes, thank you very much for this. Yes, indeed, China follows the same doctrine as Europe and the US, or the US, Europe and China are following each other in this in this approach connected to AI. Thank you very much for this comment. We are approaching to the end of our global digital encounter, and I would wish to leave each of you less than 1 minute, perhaps 30 seconds, to mention a message you would want to pass upon to our esteemed audience and to the numerous listeners who will listen the recording of today's encounter. I would leave the floor, since you just spoke last, Xue and Van An, I would wish to leave the floor first to Kung Chung.
Okay, thank you. Thank you for this fantastic questions. I think the major reason that make me doing all this Asian IP law research is that I see Asia as the least integrated continent on Earth. So Asia is the least stable continent. Of course, it was overtaken by Ukraine and the Middle East, but otherwise, Asia is least integrated. So we very much like to harmonize and integrate ourselves like the European have brilliantly done some 70 years ago. And through the help of IP, we can find common language. We're not politicians, but this is something that will benefit all Asian economy. Let's focus on cooperating rather than the sea, water, or land dispute. Thank you.
Thank you very much. I would give the floor to Van An, and then, of course, to Xue, coming from the largest country, for the last word. So, Van An?
Yes, but there's one thing I would like to speak directly to Professor Liu. That is my interest in Asia IP law, also inspired by your article about the written about the major economies. In this, you mentioned Asia is the least integrated continent. That hit me a lot because I didn't think about Asia at that time, and also from my personal observation in Vietnam that we kind of tend toward overprotection. And then when I read your article, I also said this. I also saw the same tendency that you mentioned in other Asian countries. So I think Asia, I think there are a lot of commons in so Asian countries, but if you zoom it out, you will see that there are lots of differences, and we cannot speak like for Asia in general, but we need to be very specific about each countries. And even countries seem to be similar politically, like Vietnam and China, but the path and the way that the government regulates, for example, industrial policies are completely different.
Thank you very much. The last word is, of course, for Xue, for Professor Hong Xue.
Well, thank you. Well, I appreciate all the observations from two distinguished speakers. Actually, well, Asia Pacific is forming the world's largest free trade zone, like the RCEP. It includes 10 ASEAN countries and China, Japan, Korea, plus Australia, New Zealand. So this 15 economies form a very big free trade zone. And there is a chapter on intellectual property protection. So I guess we are no longer so much fragmental. We are integral gradually. And my last message I want to convey is let's awake the sleeping patterns. Okay, thank you.
Thank you very much. Thank you for this. All these comments. So we saw in this global digital encounter the beauty of unity and diversity, and unity in models. I would wish to leave the floor to my co-director, Professor Manuel de Santes, who will formally make reflections and close this encounter. All my warm thanks to my esteemed colleagues who dedicate their time to this activity. All my warm thanks to our public who raised fascinating questions in the chat. And at this very stage, Manuel, the floor is yours.
Thanks, Laurent. Thank you. Having you today as moderator of this 30th encounter has been a pleasure and also an honor. So they are Van Han, they are Hong, and they are Kunjung. We are also very, very grateful to you. Be welcome to our family. to our unconscious family. The unconscious family is a bunch of professors and IP experts, you know, composed by more than 100 of remarkable people. Yeah. So today, I still remember until what extent 25 years ago I jumped into Asia for the first time, and I realized that the world was moving so rapidly from the Atlantic to the Pacific. Yeah. And until what extent, yeah, I think someone said, I don't remember who, that the issue does not come, the booming of patent applications didn't come from yesterday. Well, I should say it didn't come from yesterday, but it came from before yesterday. Yeah, I still remember the very moment in 2003, 2004, where we moved from the trilateral to the IP5, yeah, and I still remember my time as a vice president of the European Patent Office when my colleague Tian Li Pu, we discussed the future of patenting in China so many times. Once upon a time, there were 8,000 applications in China. and then 8,000 applications, and then our planning was by 2010 there should be at least 100,000, and by 2010 there were more than 500,000, let's say. Yeah. So does paradise mean just numbers? You have discussed this, and certainly it looks like you mentioned that with the exception of Japan and Taiwan, numbers will continue to grow in the near future. So I guess that numbers does not mean necessary growth, economic growth. Yeah. Numbers does not mean necessarily more innovation. Numbers have to be explained. In the case of China, for instance, explain also for the very huge governmental plans, yeah, which push enterprises to as you correctly mentioned, Hong, to bring patent applications, yeah. But once you manage to explain the numbers, then it's easy to understand what is behind. The reindustrialization in Japan does not mean necessarily more numbers. In Taiwan, the numbers have been reduced, but trade secrets have been increased. In Singapore, manufacturing is the very activity and not financing. Very surprised. You know, there's a lot of sentence we are going to highlight from you have said today. Yeah. And in Singapore, there are more and more applications coming from local industry. If I recall well, Kun Shundu said it. So certainly, perhaps one day we should link more clearly numbers with innovation, because what should mean is behind all this is increase of innovation. I would like to highlight today, Laurent, the excellent questions coming by the participants. Yeah. For instance, I recall the brilliant discussion on SEPs and the essentiality criteria, yeah, the new SEP European regulations, the need also, I think was Yu Hong of the need to arrive to a common understanding on the main issue of anti-switching injunctions. Yeah. And even the question whether Alicante should be the most ideal place in Europe to deal with these matters. By the way, personally, Alicante has changed enormously in the last 30 years. I do hope you will visit.
Yes,
yes,
I will.
And our university pretty soon. Yeah.
Okay,
certainly
I will.
we will deal with in the next. I was joking, of course. We will deal with these issues in many more countries in the futures. Yeah, including the renewal fees. Yeah, including the open licensing in China, including the role of trade sectors that you have highlighted. Yeah, so. All in all, I have the feeling that we could have spent many more hours reflecting on many other issues related to the bomb of IP in Asia. But believe me, you will be very surprised when reading later on the report the many questions you have brought on the table just in 1 hour. So remember again and again that the purpose of this exercise is not, in no way, is to exhaust the matter. The purpose of this exercise is to be sure that we will have in the future many other encounters dealing with these matters, and we will have the opportunity to dig on specific issues. So I'd like to also to thank all those who attended the encounter today. As always, take care, please, and join us for the next encounter. The next encounter will be the 34th already. Laurent and Javier, who could have told us that some years ago that we were going to arrive to the 34th encounter. And then it will take place at the end of April. We will tell you exactly the date pretty soon. And we will discuss another exciting topic. We will discuss patent licensing, a new avenue for business. So bringing the link. In a way, it's something that you have brought also today during your discussion. As always, we will prepare thoroughly materials. We will prepare references for you. As always, we will provide, as today, splendid speakers. So thank you very much for being with us. Enjoy the rest of the day. That for Europeans is a huge day. And for Latin Americans is even more, because they are now around in 3 o'clock in the morning. So please, greetings to you and greetings to all your families. Thank you very much for being here today, and bye-bye. Thank you. Thank you. Enjoy the day.